Hello, everyone. My name is Chris Drunovs. I'm an employment and labor lawyer at Kane Shannon Weiler LLP. We're a member of the Greater Langley Chamber of Commerce, and the Chamber has asked us to prepare a presentation for employers and businesses on issues in the workplace and COVID 19. So, we've prepared a PowerPoint presentation which we'll share with you, and I'm going to go through some of the key points in the presentation with you now. We'll start by discussing travel. As of March 12th, 2020, BC health authorities have directed anyone who chooses to travel outside Canada to self-isolate for 14 days upon return to British Columbia and not attend work or school for that period of time. As a result, it's certainly reasonable and appropriate for employers to ask employees returning from travel outside of Canada to stay away from the workplace for 14 days, even if they don't seem ill. In terms of restricting travel, you can and should place restrictions on business related travel for your employees outside of Canada. You cannot ban employees from personal or leisure travel, but you can require employees who are traveling outside Canada to disclose this to you and require them, of course, to self isolate for 14 days upon their return. You can also share, and we would recommend that you share the most recent travel health advisories regarding travel outside of Canada, and I recommend that your employees comply with them. You should also communicate any restrictions or disclosure requirements for employee travel very clearly to your employees. One big question we're getting is whether you must pay employees that are off, either sick with COVID-19 or affected by COVID-19. This, of course, will depend on the individual contracts in place at your workplace and any applicable personnel policies or collective agreements. In terms of sick leave, if the employee is eligible for sick leave, they are entitled to sick pay if they're off sick with COVID-19. If they are not eligible for sick leave and not able to work, you're not obligated to pay them. However, if there is a lengthy period where they go unpaid, this could raise concerns about a constructive dismissal and is certainly determined on a case-by-case basis. We recommend you consider allowing employees to work from home, and when this is not possible, be flexible with your policies in terms of allowing them to use vacation days, bank time, or even allow them to make the time up at a later date. Another important thing to note today was confirmed by the BC government that a sick note is not required for employees requesting sick time. So it doesn't matter what your policy says. That requirement has now been relaxed by the government. For employers with benefit plans, you should check in with the broker or the insurer to determine what benefits might be available for sick or affected employees, including short-term disability. You should also check to see whether there are any circumstances that would make your employees ineligible for coverage, including travel outside of Canada at this time. Employees should also be encouraged to contact the federal government to see if they qualify for employment insurance benefits. EI sickness benefits are available for employees that qualify. The benefit period is 15 weeks. The federal government has also announced it is waiving the regular 1 week waiting period for benefits to begin for workers who are quarantined due to COVID-19. It's important to recognize that this waiver is only available for employees who have been given notice or order from a public health official or authority to self-quarantine, or if they've received a recommendation to quarantine by their employer, a doctor, a nurse, or person of authority. So if you have an employee that is sick, give that direction to self-isolate, and that will make the claim easier for them. Currently, employees who choose to self-isolate without receiving that direction from an authority or the employer will not be entitled to a waiver of the 1 week waiting period. At this time, EI sickness benefits are only available to those who qualify for EI, so those who have enough insurable hours. This may be changing, and we'll keep you posted on it. One statutory leave that's available to employees is the family responsibility leave under the BC Employment Standards Act. This gives an employee up to 5 days of unpaid leave to help with the care, health, or education of a child under 19 in their care or a family member. This could certainly come into play for employees required to stay home, care for children, or for a sick family member. If your employment contract or policy already provides for a family responsibility leave that is equal to or greater than 5 days, then this would replace the employment standards leave. Employers have a duty to provide a safe workplace free of hazards for their employees under health and safety legislation. This includes controlling, containing, and educating employees and supervisors regarding infectious diseases. WorkSafeBC has published a guideline on this, which we would encourage you to review. It sets out the employer's obligations with respect to infectious diseases like COVID-19. Another important aspect is to manage your employees. If you have an employee that's sick or displaying flu or cold-like symptoms, you need to act quickly to safely remove that employee from the workplace and direct them not to attend the workplace. You should do the same for any employees returning from anywhere outside of Canada. Under health and safety legislation, employees have the right to refuse unsafe work. The occupational health and safety regulations outline specific procedures that have to be followed in the event an employee asserts that right, including a swift investigation by the employer to look into the request to identify any hazards and take reasonable steps to eliminate them. If you do have an employee that asserts work refusal due to COVID-19, we recommend you take that very seriously, that you investigate the reasons for the request, and that you permit the refusal pending the results of your investigation. I think erring on the side of caution at this time is probably for the best. Also be mindful of the discriminatory action complaint provisions of the Workers' Compensation Act. Those prohibit employers from retaliating against workers for raising health and safety concerns. So if an employee does raise a refusal to work issue, be sure to treat them fairly and not to take any measures that would affect their employment in a negative way. In terms of WorkSafeBC benefits, they may be available to a worker who contracts the disease at work, but only under limited circumstances. Just contracting the disease at work in and of itself is not sufficient to qualify a worker. The nature of the occupation or the nature of the employment must create a greater risk for that worker than the risk faced by the general public. This might include workers who have been required to travel to China in recent months or other hotspots. If you believe you have such a worker that may have a case, we would recommend that you immediately report that to WorkSafeBC as you're obligated to do so. There are many human rights issues that arise because of COVID-19. First and foremost, somebody who contracts the disease likely suffers from a physical disability, which is a protected ground under the BC Human Rights Code. As a result, you cannot discriminate against that person, which means you cannot treat them negatively in any way in their employment because of their disability. Employers also have a duty to accommodate employees with COVID-19 up to the point of undue hardship. This may mean accommodating by providing alternative work arrangements such as telework, permitting employees to stay home to take care of their family members, and any other necessary measures. Now, the duty to accommodate only applies up to the point of undue hardship. So when you're facing significant health and safety issues, you need to balance those with your human rights obligations. We've had a lot of questions around workplace testing and whether employers can institute mandatory temperature checks or other medical testing at the workplace. At this point, we recommend you proceed with caution around any testing. It creates significant human rights and privacy concerns, and at this point, such testing has not been mandated or directed by health authorities. It may be appropriate in certain health and safety sensitive environments, and that would be on a case-by-case basis. So if you're considering testing, we would recommend you contact a lawyer to get advice. For those employers who are collecting employee information regarding COVID, including test data, medical information, or even absenteeism information, all of that information constitutes employee personal information under the relevant privacy legislation and must be managed and protected in accordance with that legislation. Be sure that information is secured and protected and only shared with management and human resources on a need-to-know basis. Many businesses now are facing the difficult decision of whether to lay off employees, either due to a shortage of work or due to government directions. It's important to be aware that in the eyes of the law, most layoffs actually amount to a termination or a wrongful dismissal. This could potentially trigger an employee's rights to termination pay under Section 63 of the Employment Standards Act, or a severance pay under their employment contract or under the common law. If you do plan to institute layoffs, it's important to take legal advice first so you understand the potential risks and you can manage those with your employees. For those employers who have sick or absent employees due to COVID-19, you are permitted to take measures to allow yourself to continue to operate. This includes hiring temporary workers to provide replacement work or asking your healthy employees to work overtime. If you do hire replacement workers, be careful to set out the terms and conditions carefully under a fixed term contract to make sure you're not hiring them permanently and creating severance obligations for yourself. If you are asking your existing employees to work extra, be mindful of overtime rules and prohibitions on requiring excessive work under the Employment Standards Act. On the next slide, we've identified some resources for employers that we think you might find helpful. We would encourage you to review these resources as you see fit and implement any recommendations that you believe will help your workplace. So thank you everybody for listening. Obviously this is a fluid situation with new information coming in by the hour, so we'll do our best to keep everyone updated. If you do have specific questions, please don't hesitate to get a hold of us. We've provided our contact information on the last slide, and hope everyone stays well and healthy. Thank you.